So let's start with the review and approval of the minutes. The minutes were sent to you all with the packet of information from Nicole. Is there a motion? So moved. Okay, Bill, is there a second?
Second.
Jen, any discussion on the minutes? All those in favor, say aye, or if you say video, raise your hand.
Aye.
Any opposed? Any
And I
abstentions?
abstained because I wasn't there.
Sure, the Judge Spader abstains and the minutes are approved. Okay, I'm going to go out of order briefly just because Judge Rapillo needs to get back into court. So I'm going to let her, we're going to skip to item 5 on the agenda and I'm sorry, number 6 on the agenda, the Future Access to Justice Conference. And I'll let Judge Rapillo do a report for that.
Thanks, Justice Bright. So I'm happy to report that we have a tentative date for our conference. It is October 4th, 2026, from 9 to 1 at the Legislative Office Building. Many thanks to the staff who worked hard to do what was needed to be done to get that date put aside. So we've got our date set, and now we just have to get to work on what we're going to do.
Judge Rapillo, was it November 4th?
November 4th, yes.
Okay, you said October, so.
I'm sorry.
A moment of panic, but
Nope, sorry. It's been a long morning.
yeah.
So November 4th, 2026 from 9 to 1 at the Legislative Office Building.
All right, thank you. And the subcommittees, as we continue to put together the programs and things you want to present on, just keep it in mind, whatever technical needs you may have or space needs, and let Judge Rapillo know that we'll continue the conversations over the next 11 months.
Yes, if anybody has any thoughts or ideas, please just shoot me an email and we'll get right on it. So thank you, everyone.
Thank you. Okay, so does anyone have any questions or comments about the conference next year? Okay. More about that as we get closer. So now we'll go back up to number 2 on the agenda, which is a presentation of the Connecticut Bar Foundation Legal Needs Assessment Report with Angela Schlingheim. Did I get that right?
Yeah.
Okay.
Just cut it in half. I know it's
Yeah.
it's a lot of consonants.
Yeah.
Well, it's good to see everyone. As Justice Bright said, my name is Angela Schlingheim. I'm the Executive Director at the Connecticut Bar Foundation. I'm very happy to be with you all this afternoon to share the most recent results of our current civil legal needs and economic impact report. So Nicole's actually going to put up the PowerPoint because I don't have access to Wi-Fi
Okay.
through the judicial branch. But I'll just start by saying, sort of when we decided to do this report, it had been quite some time in Connecticut since we had done a legal needs report. And we really thought about what we wanted to do. And obviously we wanted to assess the current needs of the low income population in terms of civil legal needs. But we also really wanted to look at our entire system in terms of access to justice. What are the strengths of our system? What barriers and gaps exist for our system? And then what recommendations could we come up with to actually close some of these gaps and improve the system so that we could have an overall stronger system in Connecticut. And I just want to say thank you. There were people from this commission, from the legal aid community, from the judicial branch who spent a tremendous amount of time and energy in helping us collect data for this very, very large project. And we're very proud of the outcomes. So we'll get right into it. Perfect. If we could just advance a few slides. You could keep going. I'll tell you, if you could go to the slide that's prevalence of legal aid. There you go, right there. Thank you so much, Nicole. So I don't think for this first part of the presentation, there's going to be a lot of shocking information, but we have to start with the foundation about like what is the prevalence of need. And we did a survey of the low-income population in Connecticut. And what we found is that 72% of Connecticut's low-income residents, that's around 400,000 people in total, have experienced a civil legal need in Connecticut. And here you can see how that breaks out by need. Again, I don't think these are a lot of shocking information, but housing, children and family employment, public benefits and healthcare, consumer debt, fraud protection, person with disabilities, elderly, immigration. These are the areas that the low-income population has the highest amount of legal needs. And 41% of Connecticut's low-income families have experienced 2 or more different kinds of civil legal needs at any given time, which again is not uncommon for people living in crisis. And what we also learned is about the impacts of these civil legal problems on the individuals, right, which can then affect our communities. So increased stress and anxiety, impacts on physical and mental health, increased expenses, loss of income or benefits, loss of access to basic need or services. These things all put tremendous strain on other systems in Connecticut. And frankly, with everything going on and the continued strains on basic needs and services and seeing how that is going, we're going to see a tremendous increase, I think, in that last 27% over the next few years, dealing with the shrinking social safety nets that the low-income population depends on. So again, not a big shocker. The survey showed that most low-income residents cannot afford to hire an attorney, and without the legal aid attorney on their side, they have to navigate a very complex system on their own. And as one of our survey respondents said, the legal system in general is a maze that no simple person can get through. And that's really how the majority of the legal aid clients feel, is without that support, they're just not going to be able to manage the system. So I think it's important to focus on what the current strengths of our system are, because in Connecticut, we have done a lot of work to support this access to justice system and support legal aid. And in 2024, almost 21,000 low-income residents in Connecticut received services through our legal aid system. That includes over 1,500 children, almost 6,000 individuals with disabilities, over 2,500 adults aged 60 and older, and more than 500 veterans. So these are our most vulnerable populations within an already very vulnerable population that receives services through our system. And no surprise that when clients received legal aid services, they were 2.5 times more satisfied with the resolution of their situation than they would have been had they not had any legal assistance at all. In addition to the legal aid system, we have other points of access to justice in our state. So nearly 187,000 self-represented parties were assisted with court service centers and public information desks in 2024. And ctlawhelp.org was viewed nearly 678,000 times. I think what this shows, again, is how much work Connecticut has already done. We have a lot of points of access to the legal aid system and our access to justice system in Connecticut. And people are using that system. And, you know, I think it's great to point out too that CT Law Help was really the first of its kind in this country. And a lot of other jurisdictions have based their self-help websites off of Connecticut's ctlawhelp.org. So we do have a lot of points of access to our system. Having said that, I think everyone in this room knows that we also have a lot of barriers to our system in Connecticut. And the demand for civil legal aid, that the data shows, far, far exceeds the current capacity of our system. Nearly 2 in 5 low-income residents who sought legal aid just could not attain the help that they were looking for. And looking at our hotlines, so this is like one of our most vital entry points to the legal aid system. It's extremely strained. So we had nearly, over 139,000 calls to the hotline in 2024, but 31,000 calls were disconnected just because of high volume trying to get through the hotline. And 25,000 calls came in due to at the times when the hotline was not open. So although this is an incredible resource for the legal aid system, as you can see, it is extremely strained and just can't meet the need that we have in the state. Also, among low-income residents who experienced a civil legal issue, but for whatever reason did not seek legal aid, more than 1 in 3 said that they were not familiar with legal aid at all. Roughly 1 in 4 said that they didn't think they qualified for legal aid. And there was approximately 2,000 individuals who called the hotline who were denied services because they were over income for the income eligibility standards. And, we do a lot. Our organizations do a lot of outreach. But clearly there are still people in our communities who just don't even know that help is available to them when they need the help. So this slide, I think, is really important because it starts to highlight that the gap between the services legal aid is able to provide right now and for certain legal needs and the legal needs that are not getting their needs met. And there's I think a lot of very valid reasons for why this is happening. So as you can see, housing and children and family, they make up like 80% of the legal aid cases right now. And although the other areas make up about half of the legal need cases, they only represent about 10% of the cases that legal aid is able to take on. And there's, I think, a couple of reasons for this, and Jamie and Giovanna, you can tell me if you think I'm accurate or not, but I think there's sort of 2 reasons for this. One, with eviction defense and particularly family around domestic violence and restraining orders, there is extreme and urgent dire need for many of the individuals of those cases, so they oftentimes take priority. But I also think part of the reason is that in the last few years with Right to Counsel, we've had very specific funding that has to be used for those reasons, for housing and family. So those dollars can't be used to give services for other types of civil legal needs. And so what ends up happening is that there's a large number of legal needs that we just don't have the capacity in the system the way it's set up right now to meet. We're also seeing some unequal access to legal aid by county. And so you can see Fairfield, the need is at 27%, but the cases for legal aid is at 18%. And we see that also at the bottom of the screen with Litchfield, Holland, and Middlesex. Again, I think there's a variety of reasons for this. In Fairfield County and in some of the more rural areas too, it can be really challenging for legal aid to hire for people to live in and work in those areas. In Fairfield County, the cost of living is very high, and it's incredibly difficult sometimes for legal aid to hire people who are willing to live and feel that to work and can feel they can live in that area. And it's the rural areas are always a challenge. Also in Fairfield, some of the feedback I've gotten is that there are people who come for help who are not at 125% below the federal poverty level. They are 200% below the federal poverty level, but that does not qualify them under our current system for legal aid. So it's just that gap between legal aid and being able to afford an attorney and all those people that fall in between. Also, we're seeing that older adults, based on the data, are less likely to access legal aid for their civil legal needs, with about 32% having legal needs, only 19% of legal aid cases. I think with the older population, there's a lot of potential reasons for that. People can be very isolated. they may not have knowledge or access to technology to use some of the websites and other points of access to the system, things like that. In addition to looking at the legal needs, we also wanted to do an economic impact assessment for legally in the state. And I will start by saying that in my opinion, our impact is actually much higher than what the report showed. And the reason for that is we learned a lot during this process about what kind of data we're collecting. And as a system, I think we could come together to do better to collect some of this financial information in a way that we can use it in the future. Because I think if we had that financial information, these numbers would be even higher than they are, which isn't to say that they're not good already, but I think it's an understatement of the impact. But for 2024, with $10 million in benefits to clients, it generated $12.4 million in economic activity in the state. And over 5 years, with $66.8 million in public funding, that generated $190.9 million in economic activity in the state. And we saw 11.7 million in increased household income over 5 years for individuals who were able to access related services. And so what that means is that for every dollar spent, there's nearly a $3 return in Connecticut on an investment in legal aid. Which I don't think is a surprise to anyone in this room, right? When we invest in legal aid, we support our communities, our state is healthier, it's financially stronger, our families do better. But now we actually have data and a report where we can go to funders in the legislature and really show that to them. Next slide. So now that we know all this information and we understand our strengths and our gaps and barriers, the natural question is, well, what do we do with all this information? So one of the things that we really wanted to focus on with this report is coming up with recommendations to actually try and move our system forward from where we are today. So obviously strengthening hotline capacity and coordination will be important based on the data that we learned throughout this process. And that's something that we at CVF will be working with statewide legal services as well as our providers who rely on that hotline to get referrals. We'll most likely be putting together a task force so that we can really look at the most efficient way to be using our hotline, how we can incorporate technological advances into our hotline to serve more people, and what that looks like from a cost perspective. Also, CVF is going to be working on a project around salary parity, retention, and mentorship. I don't think it's any secret that legal aid attorneys don't make enough money compared to their counterparts at other public interest positions within the state. And we want to look at that and understand what that gap is so that we can try to correct it. In terms of increasing resources for service delivery, obviously this is always on our mind. From our perspective, that means really two things. One is working more closely with our banks, developing stronger relationships, bringing on more leadership banks so that we can increase our funding through the IOLTA stream, as well as continuing to work with our legislature to let them know what the needs are, and just being aware and open to other potential funding opportunities that may exist for our system. Expand housing crisis response. I think everyone here knows what's happening in our state in terms of our housing crisis. And, obviously we are the program administrator for the Right to Counsel Eviction Defense Program, but that's just really a small piece of the puzzle. We do work closely with other stakeholders in the community who are working on issues around affordable housing and issues around changing legislation for how landlords can evict people and at what point. So we're continuing to work closely with our stakeholders to move that forward. In terms of the geographic gaps, we'll be working directly with the legal aid providers who cover those regions where we saw the gaps to try and help them figure out innovative ways to deliver services. in terms of hiring and retention, hopefully the salary parity study will help us on that front, but there are other issues outside of that that cause gaps in some of those areas. And so we'll work to come up with innovative ways, whether maybe it's around mobile delivery of legal services in the more rural areas and meeting people where they are so that we can make sure the services are getting to them. Okay, so this is one where I'm really hoping this commission can help out with. And I know this is controversial, but I feel very, very strongly that we are at a crossroads where we in Connecticut, but across this country, have to really take a look at our service model and understand how we can incorporate legal practitioners, community justice workers, social workers into our legal system. I think what we have learned over the many, many, many years of doing this work is that we are never going to have enough attorneys to meet the need of every single person who has a legal need and who is low income. And there are a lot of legal issues that if we had legal practitioners and community justice workers working in tandem with our attorneys could really focus on some of the more complex litigation that has to go on and do more work and have more impact than they can right now because they're trying to do everything. So my hope is that the commission will really do some work around analyzing what this looks like, understanding what's happening in the country. So many other jurisdictions are already looking at this, and the CBF is ready to work in tandem with the commission to help move that forward. Obviously, it's going to involve a long-term commitment, and it'll be a lot of work around changing statutes and things like that. But I do think that that's going to be an essential part of increasing access to justice in the future. Modernizing technology and information management. I know our Chief Justice was really committed to the modernization of technology in our court systems and was already working on moving towards that plan. Information management. One of the things that came out of this was really understanding how we collect data in our system for legal aid and coming up with some ideas to make it even better than it already is so that we can have really good data to show the impacts and outcomes and understand what our next steps should be always moving forward. And, this next recommendation is really around AI. I know everyone's really sick of talking about AI, but I don't think it's going anywhere. And there's some really great work being done around how AI can increase access to justice and really democratize access to justice. And I think incorporating some of those tools with our ctlawhelp.org is well within our reach. A couple of examples quickly from other states. New York City has 2 AI tools that they launched in the last year. One is called Depositron, which helps individuals get their security deposits back. So they can go online and type in natural language what their situation is and get a letter that meets all the statutory requirements, as well as detailed instructions in their language that they can then use to make sure that they are getting their security deposit back. And there's a similar one that deals with conditions issues. Obviously they're new, so we don't have a lot of data on like how it's helping, but I can guarantee that it's freeing up a lot of the legal aid attorneys' time in New York City having access to these tools. Supporting systemic reform and policy advocacy. This is really about just making sure that we're focusing on not just going to the legislature to ask for money, but really looking at our systems and policies and advocating for changes in statutes for those things, as well as around the funding. And then the last recommendation is really about building capacity to serve like those legal needs that we talked about, as well as strengthening pro bono engagement. I really see this as an opportunity for the pro bono community to have a focus on some of the legal areas that they could really support the legal aid organizations with helping. I know this has been an ongoing discussion in Connecticut about how to improve our pro bono system. And so we've tried so many things and we have so many attorneys willing to do the work. Some of the feedback I've gotten from providers is that it's really hard for them to sort of administer dealing with pro bono attorneys and training them. It takes a lot of their time and energy, and then they don't necessarily get more than like 1 or 2 cases out of them, and then they move on. So maybe figuring out a more coordinated system that the burden doesn't fall on the legal aid providers to sort of administer might be helpful moving forward. But I think there's a lot of conversations to be had around that. So that is sort of the nuts and bolts. You can read the full reports if you have a couple hours. Well, they are on the Connecticut Bar Foundation website, or you can scan the QR code there. But I'll just say that from my perspective, I feel really proud to live in Connecticut, and a state that has already dedicated so much of its time and resources to strengthening our access to justice for our low-income communities. I know we have a lot of work to do, but I feel really hopeful that between the CBF, the legal aid community, the Access to Justice Commission, and the private bar as well, that we can really take these recommendations and turn them into real change for our state. So I am happy to answer any questions. I know it was a lot of information to share at one time, but if anyone has any questions, I'm happy to answer them now or at a later time.
Thank you, Angela. That was great. Does anyone have any questions for her about this? I mean, I had one question that I hear come up in different presentations, that when you ask people whether they have legal problems or what legal problems they have, a lot of times they don't even realize that the issue they have is a legal related issue. Did that come out in the surveys at all?
Yes, I mean, I think that is a problem when you have someone who's not trained in the law. They may have a problem that they don't even understand can be remedied through the legal system. And I think, like I said earlier, our system already does a tremendous amount of outreach, and that's part of it, is trying to address some of those issues so that people do know what they can go to legal aid for. But, perhaps there is room for us to re-examine some of our outreach efforts and tailor them more around that very specific issue, to make sure that people understand even when they're having an issue that can be helped through the legal.
Yes. Do you have anything you want to add on it?
Good job.
Great.
Thank you.
This is quite a nice, go ahead.
You mentioned the community justice worker idea, and that's something you'd love to see this commission work on. Do you have any sort of tentative proposal, or what would that look like to you? Have you thought that? Have you gotten there yet? Or
So I personally don't have my own thoughts about how this could specifically work in Connecticut. I have tons of information about what's going on. And, I know Judge Thomas and I have talked about this also offline for some of our fellows programming. I think the first step really has to be trying to understand what would work in Connecticut, right? Because, Alaska has a very successful community justice worker program. I think they have over 400 community justice workers right now. But, Alaska is very different than Connecticut. Their system was created because of all the legal deserts they have. So they were deploying hundreds of community justice workers out into these rural areas to ensure that people who lived in those communities could access some type of legal help. So I don't think that model is the correct model for Connecticut, because we're not Alaska, but I do think that there is a lot of room for us to look at what could a legal practitioner do? What could a community justice worker do? What does that look like for licensing, for what specific areas that those individuals would be able to help with? And then the social worker piece is really more about like allowing our legal aid providers to have more holistic services within their organizations so that when people are in crisis, they don't have to go to 20 different places to get the help they need, right? Thanks.
So this took, what, over a year to do the study? Or
It was a year and a half between all of the data collection and analysis. And it's not easy to collect data from all this different places we did. But like I said, everyone was extremely helpful. But it was a lot of information to collect, and because we do have a lot of things we do in Connecticut already. So it was a long time, but I think well worth the effort.
So I agree, and I think that each of the subcommittees, I hope, will kind of keep in mind what we learned through the study, both in terms of positives, of where we still have the gaps, and where we might be able to find solutions to some of those gaps. And I think Angela's provided us with some good starting points.
Yeah, and I'll just again say, you know, from my perspective, the CBF is available to the commission. So if there's anything that you feel we could help with or support your efforts of the different committees or information you need, please do not hesitate to reach out to me. You know, we consider ourselves partners in this work, and we're happy to support the commission in any way that we can.
Thank you. I don't see anybody on the remote have any questions or comments. Okay, so thank you very much for that.
Thank
You're welcome to stay, or.
No, that's
you have to go?
okay. About 500 emails to get back to you, but I appreciate it.
All right, so the next item on the agenda is the update on the proposal to amend the discovery rules and summary process matters. And I thought the way we might go about this is I'll have Ivana talk about it, and then whether Bill or somebody else from the judicial branch's perspective, and then Judge Thomas, who is kind of the person who helped put this all together, talk a little bit about how he sees it from an access to justice perspective. And then we'll decide what we want to communicate, if anything, to the rules committee, which is meeting next week.
Sure, thank you. And I would defer to Judge Thomas as well. We did meet with folks from Judicial Court Ops, including Becky and Krista. I think Kai's was in some of the meetings. Bill, Travis Claxton, the mediator, joined us, as well as Judge Thomas. I don't know if folks got copies of the revised proposal. It wasn't had, I have some paper copies and folks prefer that. I think the sense from the last time you were here is that the Access to Justice Commission wanted to focus on the mandatory disclosure provision, the new proposed provision, which is page 2, the flip side. And we did work out some compromise language, which is featured there, to really focus on cases alleging non-payment or summary process cases in which either party raises the issue of a financial obligation. And it requires that no later than the first court date, the plaintiff shall provide an appearing defendant tenant with a copy of the most written lease, if any, and a copy of their ledger or other accounting if one exists. So I'll let you all take a look at the language. I mean, my contracts professor used to say, you know, what makes it a deal is that everybody's a little bit sad about part of it, right? But it really means a lot. I think it would really mean a lot to the proponents to, you know, have the support of judicial court ops, mediators, and to have the back of the Access to Justice Commission. And I know that Judge Thomas pointed out it's important to have discretion for judges in fashioning appropriately. So with that, I'll leave it to either judicial or Judge Thomas to comment.
I mean, Attorney Shea's correct. I mean, we worked out something that allows for cases to be scheduled, allow for this discovery, especially with the ledger, to come in where it's necessary to make sure that people have the adequate information in order to make decisions And it leaves the judges with discretion, that they need for each individual case. Right now.
I see those nods from the other commission. So Judge Thomas, do you want to kind of give your perspective on discussions and kind of where you see this as fitting in the access to justice picture at all?
So I think the sentiment from our last discussion, from the comments and names, members of the commission were supportive of us finding some version of this. For everybody involved, I think the underlying principle is that mediations, tenants participating in mediation and landlords participating in mediation should have access to the information that is relevant to those discussions, and that the mediator, in order to broker effective settlement, should be able to have access to that information as well at that first point in contact with the court system. I appreciate that. I think at the end of our last commission meeting, the concerns were earlier versions of this mandated that a continuance be granted or mandated that judgment could not enter. And I appreciate that the earlier revisions that were made address those concerns. I think that raises concerns for any judge interpreting the rule that affects our discretion. So I think those changes were made quickly and allowed us to build a consensus. The other kind of discussion that we had is the statute obviously requires the provision of the ledger, and this connects that obligation to provide the ledger with where I think it's going to be most impactful, which is in the courthouse on that first mediation day. And then, although the statute doesn't necessarily encompass the obligation to provide a lease, the two typically go hand in hand, meaning if there are any charges on a lease in excess, or sorry, on a ledger in excess of just rent, you lease to back that up. And so I general sense after the discussions, which went on for quite some time over the course of several meetings with everybody being, I think, appropriately flexible, thoughtful, is that this does represent appropriate compromise and also advances access to justice in the sense that it promotes more informed mediations, which we give everybody an opportunity to achieve this. Sometimes not achievable after a trial, which is agreements that put landlord-tenant relationships back together, which do so in a sustainable manner. We don't want people to agree to something they don't fully understand or agree to amounts that in excess of what they actually know.
Anybody have any questions or comments? Judge Berger?
2 years ago, in the context of debt collections, in a scenario where we have practicable provision, lawyers were sending by way of the standard service requirements. They were getting, I recall this, information was getting to someone, whether it was the court and or attorneys after the first account. As I read through this, if I extend the disclosure through what is deemed a method of service specified by mailing address, I represent a defendant. My friend over here sends me the information because he can under this. I won't get it at the first court appearance. So I think we need to study this up to make sure that they get it first at the court appearance and or and by the usual method. So I can see this not working.
So I think that's a fair comment. That may be a comment more appropriate or directed to the Rules Committee than to the Access to Justice Commission, because
Let's rewrite this.
right, and I will be at the Rules Committee meeting on Monday as the chair there, so I can bring that concern forward. But I don't know, I mean, one party that hasn't had a review of this would be the plaintiff bar. So my guess is the rules committee is probably going to send it out for comment to, other organizations. What I just want to be able to report back to the rules committee is whether the Access to Justice Commission views this modified proposal as advancing the cause of access to justice. I gotta keep my hats separate, so. So I guess I'd like to hear from anyone else who has who wants to express a view on this from an access to justice standpoint. And we're really focusing on the proposed new language, not for 15, changing the time periods from 30 days or 60 days to 15 days. Right? Okay. Anyone else want to say anything from an access to justice standpoint? In the room or not? So I guess the question I have for the Access to Justice Commission is there anybody who wants to make a motion that the commission take a position on 13-12B as relates to access to justice in response to the Rules Committee's request?
I'm allowed to make a motion on that.
Yes.
So
Okay, and your motion would be that we
support the 13-12P
as modified.
proposed changes as modified as being supported.
Is there a second?
I'll second.
Any further discussion on this? Hearing none, all those in favor, say aye. Raise your hand.
Aye.
Aye. Any opposed? Any abstentions? All right, so I will report to the Rules Committee on Monday. I think what Giovanna's going to do is she's going to file this revised request with the Rules Committee. It's already on the Rules Committee's agenda. There's a kind of a placeholder for it. And then at Monday's meeting, I'll inform the Rules Committee that the Access to Justice Commission unanimously voted to support 13-12B as improving access to justice. Okay. And I will at that time, Judge Berger, raise your concern about the service issue and making sure that the mandatory disclosure is done in a timely way.
Thank you.
Thank you, everyone, for working on it. I think it was good work and a good example of how this commission worked well together. All right, let's move on then to the discussion of the subcommittees, the pro bono subcommittees first. Judge Stewart is in a hearing, so she can't be here today. I told her I would provide a report. It's going to be a meeting, I think, next week. Is that correct, Moy? With Moy and Ed Heath and Judge Stewart to discuss setting up a meeting with the Hartford Corporation Council Group to try to find out from them where their interests are in pro bono and what we can do to kind of create more interest. Is that fair, Moy?
Yes, we're having our meeting next week, and then hopefully we'll be able to do a listening tour with some member in-house departments, legal in-house departments.
So the listening tour piece is continuing, and then on the other side, the implementation piece, we had a meeting last week, and we talked about where we should be devoting time there, whether it makes sense to continue to work on a website which not enough people use and not enough people know about. So we're talking about that and other ways of implementing pro bono initiatives. Interestingly, one of the things that is happening that relates to the website is there's a group called Paladin who does pro bono work in a number of states, and the service, they have their own website. And as I understand it, what Statewide Legal Service is going to do is take the pro bono website. They'll still, when people log on to it, when this conversion happens, the link will still be live, but it will take you to the Paladin site, and the Paladin site will provide the connection between providers, interested pro bono providers and need. It's my understanding I heard a little bit about Paladin at the National Access to Justice Conference, is that it's, a lot of states have found it very easy to administer, and it doesn't require legal aid providers to post opportunities 2 times, it posted once, and then it automatically gets linked in. And a number of law firms also use Paladin for finding pro bono opportunities for their attorneys. So to the extent law firms are already using Paladin and the legal aid community use Paladin, there might be some good synergy there. So I think that change, it sounded like that change is coming. It's just a question of when it's up and ready to go. Anything else from pro bono perspective? Moy, anything you can think of? Anybody else on pro bono? Okay.
I think we
Justice Bright, can I jump in on my committee report? Because I have some parties waiting for me in the courtroom also.
Yeah, go ahead, Judge Vader.
All right, so for the law libraries and law school subcommittee, the law librarians are doing what they always do, which is, very beneficial to getting the message out amongst librarians, and they're doing their usual great job, whether they're on the subcommittee or not. The last time I reported, we were working on a project, and I was looking for law student volunteers. I've gotten a number of volunteers from Quinnipiac and Yale, and I'm going to have a first meeting of the committee I've put together of law students to work on the web series that we were discussing to help people with restraining order applications and how to handle themselves in court for placement on the judicial branch website. I'm still hoping that we can have some tangible product by the end of next semester. But I'm going to have the first meeting of the students coming up next week. So it is in process and it's coming along.
Great, thank you. In this same group, Krista, and I'm going to surprise you here, can you talk a little bit about the updated slide deck we put together for libraries?
Sure, so Claudia Jalukas here as well.
Okay. Claudia.
Hey, Claudia. So we, in conjunction with the law libraries, we put together a sort of a tutorial for self-represented parties and all the services and all the resources that are available in the courts. And there are people, Justice Bright said it before, who don't even know they have a legal problem and may go to a public library and engage a public librarian. And we want those public librarians to know, because they're open on the weekends at night, that when the courts are open, you have a name, you have a place, you know the services that the court provides, you can refer them for their legal matter or ctlawhelp.org. So it's a beautiful presentation that was put together. The law librarians really did all the heavy work. And the court service centers as well. We did a practice run, right, Claudia, last week, I think, to see how long it would take. So we hope to have it updated, even just an abridged presentation for the commission to look at and see what that looks like. So Claudia, if you want to add anything.
No, I think you covered it mostly.
They did a great, amazing job.
Yeah,
Thank
it was really, really good.
Yeah.
So, thank you. All right.
And just, I'm going to log off, but I just didn't say it during the previous report, but I appreciate the work that Judge Thomas and all the court ops people and Travis did in putting together that previous rule proposal. Just, that's how it is supposed to work. Yeah, everyone comes together, and I know court ops did a lot of work negotiating back and forth to work on a proposal that kind of took care of everyone's needs. And as you indicated, Justice Bright, it didn't go yet to the plaintiff's side, and that comment will come out of rules, but I appreciate all the work that everyone put into that proposal. And I thank everyone for that.
Thank you, Judge Vader. All right, Judge Demiola is not here today, and I don't have a report from our subcommittee. So, Judge Thomas.
Yeah, so I think I've recorded in previous meetings that we've been focused on 4 areas in our subcommittee. We've been prioritizing our efforts on eviction diversion discussions. We've actually kind of formed a partnership with Judge Demiola's subcommittee to connect her into those discussions because they've been exploring the possibility of navigators, other resource individuals connected into the eviction process, and our subcommittee has been focused on eviction diversion initiatives broadly. And so there seemed to be an alignment in our efforts. We met last week. We're exploring a couple of things, one of which is to try to connect in what I keep referring to as sort of bringing back the past to the present. We're making rules old new again, which is connecting the availability of eviction prevention assistance in with the eviction court process. There's a new Department of Housing Eviction Prevention Fund that is more stringent than the NICT program, but may create some opportunity for that. We've also been looking at the default rates and ways in which we might be able to, within existing rules and processes without necessarily changing statutory requirements, maybe try to address that with some additional notices issued through the Edison system. And then, so hopefully we'll be meeting with somebody from the Department of Housing on the Eviction Prevention Fund 2.0 sometime soon. We'll also continue our discussions with the National State Courts to try to get their assistance with some further discussions around eviction diversion, where we might be able to potentially pilot that here in Connecticut.
Any questions? Okay, thank you. Does anyone have any questions or other comments regarding any of the subcommittee's work before we move on to the next agenda item? None? All right, the report on the National Access to Justice meeting. So since our last meeting, the national meeting was held in Atlanta. Jen went, Angela went, the Chief Justice went, and I went. It's always good to see what other states are doing. I don't think we always need to reinvent the wheel. Illinois, they have what, a dozen full-time access to justice people working in their judicial branch. So it's always good to hear kind of what ideas they've come up with and figure out what we can steal. And it's also good sometimes to be able to help other states with things we've done that other states have. So I asked Jen to kind of comment on a couple of things she learned from there, and I will as well. So Jen, do you want to go first?
Sure. So one of the things I was reminded of, I don't know what I learned is that Connecticut is already doing pretty darn well compared to some other states. And as Angela had said earlier, it is nice to be able to be from a state where I'm in the lead or ahead of others on access to justice. Having said that, of course, there's a lot more that we can continue to do here in Connecticut. A couple more specific things that really stood out to me. One is court reminders, and there are several states that have now started doing text reminders for court dates or phone reminders for court dates. My understanding is here in Connecticut, we do that in some criminal cases, and we have a reminder system for our jurors. We don't have a reminder system for anyone at all in civil cases or across the board in criminal. And so that's something I'd love to sort of look into, the cost and feasibility of implementing some sort of reminder system to hopefully bring down some of those default rates that maybe people are not showing up because they didn't see the piece of paper that said they should show up. That was one topic that really stood out to me. Debt collection was another. Debt collection is something that you can help people avoid debt collection. You can also often significantly affect their life, but that's one of those things that is very often a tipping point for people. That it's the debt that is crippling that then forces them to take actions or make decisions that they lose other benefits or may not be able to afford their home then because they're so busy trying to pay off their debt, things like that. Here in Connecticut, we actually have some really great policies on debt collection. But we're trying to look into how they're being enforced. Does everyone know about them and what we can do to make sure that we're really using those as effectively as possible.
Thank you. So, Jenna's being polite on the debt collection. There was a study done by the National Center for Access to Justice that says Connecticut has these really good procedures for making sure that debt collectors, particularly third-party debt collectors, are providing all the documents they are supposed to provide in terms of the contract, the effectively the ledger from the debt collection to show that they got the proper assignment. So we have all of that stuff in our statutes and rules, but in small claim, they did a study of small claim actions and found that in almost every single small claim action they looked at, the small claim magistrate did not enforce all of those obligations. So it may be more of a training issue that we need to undertake with respect to some of our magistrates. I've gotten the study and I've looked at it, and I've talked to David Udell from the National Center for Access to Justice, and I don't have any reason to doubt that their analysis was correct. So Having good policies is part of it, but implementation is the second part, and maybe we do some work on the implementation. So the other things that I wanted to mention, one is, these have kind of come up already. The eviction diversion, I talked with Samira Nazim from the National Center for State Courts about eviction diversion programs. She has since sent me notice that TD Bank does every year. They give away 40 grants of $250,000, and she suggested that if maybe we could come up with an idea where we could apply with the National Center for State Court. It may not be the Access to Justice Commission, maybe it's one of our legal aid agencies, maybe it's Connecticut Bar Foundation, but I think that if we can work with the National Center for State Court with some of these, it might provide us access to resources that we otherwise don't have. So they've always been interested in doing stuff. We've tried doing stuff with them in the past, and it didn't work, but they've always been nice about it. So, and part of the reason it didn't work in the past is they thought we were already too far ahead of the curve, and that there were other states that were further behind that needed more help than we did. But now they've actually reached out to us, so that's good. The second thing that I really think we should do, and I've started exploring, is adding non-lawyer members to our commission. I think I may have mentioned this once before. Washington State does it, and it's one thing to have lawyers or people who work within the system talk about ideas to improve access to justice, but unless we're actually talking to the people we're trying to serve and have representation from people we're trying to serve, I don't know if we're actually solving the problems that they need solved, or that we're doing it in an effective way. So Washington State has some community members. I think the model that I'm thinking of might be that we have a member, a non-lawyer community member, but that we identify a number of community organizations around the state, and we ask them on a rotating basis to have one of their members be the representative for the community organizations on the Access to Justice Commission, so that they can take back to their members and say, this is what they're thinking about doing. They just wrote this whole new rule for eviction cases. Will that help? And have them say, oh, it's a great idea, or no one's going to understand this, or if there's something missing that you need to solve here. So I trust our legal aid providers who are dealing with that population every day, but I still think having that perspective from non-lawyers would be helpful. You guys tell me if you think I'm wrong about that. But so I've reached out to some people, and we're going to try to reach out to others who have connections within mostly our urban populations to try to find some of these community people who are very active in providing non-legal community services. The third is the justice workers and non-lawyer navigators, paraprofessionals. I completely agree with Angela that we can work on pro bono forever. We're never going to have enough lawyers to meet all of the demand. There's never going to be enough legal aid funding to meet all the demand. We're never going to get enough money from the legislature to have a right to counsel on every case where someone needs a lawyer. And a lot of these cases are cases which economically just does not make sense for lawyers to take. So we ought to be looking at we ought to be thinking outside the box and thinking about other solutions. Other states are doing it, Colorado, Washington, New Hampshire, Arizona, New Mexico, Utah, Nevada, Oklahoma, District of Columbia. All of them use non-lawyers to provide some services to help people navigate the court system. Some are literally navigators who are at the courthouse, and people come in and say, where do I go? Now, we have our court service center. They get overwhelmed at times. I've always said that I think the two hardest jobs within judicial are the court service centers and the housing mediators, because they just get inundated with people who want their problem solved, and we tell them help, but don't provide legal advice. which is a difficult line to walk. And two, a lot of the problems can't be solved in that setting. Having some other people involved, Illinois is using AmeriCorps. People get out of college, they go to work for AmeriCorps, and their job is to work in the court system for a year, provide some type of non-legal assistance to people there. Kansas, and we've talked a little bit, I've talked to Judge Berger about this, uses retired attorneys to come in, work as court navigators and help people work through the process. Nevada uses social workers as part of the system. Some people in some states, it's the states that will hire the non-lawyers. In some states, it's the cities that do it. Tulsa, for example, does that. And in some states, it's the legal aid organizations who are able to do that with what funding they have. And then some states are looking at limited licensure for paraprofessionals to handle certain things, including in some circumstances going into court and handling matters that lawyers just aren't capable. I think all of those are worth looking at and considering. I think we should kind of do a survey of what all the states, other states are doing, figure out what might work here. As Angela said, some states, they have these large geographic legal deserts. And that's what motivated them to do that. We're a small state. We really don't have geographic legal deserts, but I think that there are some parts of the state where we have effectively a legal desert because there aren't enough lawyers, whether it's in the northeast corner or the northwest corner of the state. So that was the third thing I kind of took away that I'd like to see us devote some time and effort figuring out. Any have any questions about any of that? Okay, so any of the subcommittees who are interested in any of those ideas, let us know. Otherwise, we'll just kind of start maybe setting up other working groups to look at some of these topics. We've already discussed the future Access to Justice Conference. The next item on the agenda is such other matters as may come before the commission. Does anybody have any other issues they would like to bring up or discuss today? Okay. Future meeting, our next meeting. My thought is that I really want to give the subcommittees time to work coming into the holidays. So my thought is to maybe have our next meeting towards the end of January, and then maybe another meeting in April, and then one in June. With the hope that by June we know what we're doing for the conference in October, and we have a good plan in place. And then we'll have one more meeting in September before the conference. So that would be, that's, if you're thinking of planning, that's what I would see for the rest of this year. You need to do them on Wednesday afternoons at 2 o'clock. All right. Anyone else have anything? Okay. Is there a motion to adjourn? Okay. I was gonna say, everyone wants to keep, we can say, you're at. Judge Thomas moves, is there a second? Berger, a second? All those in favor say aye. Any opposed? Okay, Claudia wants to hang around too. All right, we're adjourned. Thank you, everyone. I appreciate all your time.
Thank you.
Thank you.